Hi, besties. If you were wondering what happened with Blake Lively's letter motion yesterday, here's the breakdown. In that filing, Blake essentially asked the judge for more time and insisted the motion should be denied simply because she said so. This was in response to Wayfair's motion for judgment on the pleadings, which is basically an attempt to throw out most of her case entirely. Well, Kevin Fritz, the scorched earth attorney we've seen before, came back with a response that was sharp, well-structured, and in my opinion, devastating to Blake's arguments. Right from the start, he cuts into her claims. While no one can say for sure how the judge will rule, the foundation of his argument is solid, and he makes a compelling case to the court. Fritz emphasizes that a motion for judgment on the pleadings is always permitted after pleadings are closed. It's not something that's waived until the end of trial. It can be filed at any time once the proper conditions are met. Blake argued that Wayfair had sat on their rights for nearly 9 months and that allowing the motion now would waste resources and duplicate work. But Fritz points out that's simply wrong. The operative complaint was not filed 9 months ago. It was filed just 2 months ago, after Blake herself amended her case following the dismissal of her claims against Jed Wallace and Street Relations. Blake wasn't required to amend her complaint, but she chose to do so. On July 30th, 2025, she filed that second amended complaint. Once she did, Wayfair's time to answer was reset, and only after they answered could they move for judgment on the pleadings. In fact, at a hearing on July 30th, Wayfair explicitly told the court they were considering a Rule 12c motion. Blake knew this, and if she was unprepared to oppose, that's on her, not them. Then there's the issue of the CRD. Blake's complaint never attached her CRD documents, which is a huge problem under federal law. To sue under Title VII, you need an EEOC right to sue notice, and her filings didn't provide one. She also failed to state when she filed with California's CRD, which is required to confirm timeliness, and she didn't attach the CRD complaint itself. That makes it impossible for the judge to verify that the parties she sued actually match the right to sue notice. Her original December 2024 complaint included claims against It Ends With Us the movie, but without the required documents, she had no legal basis to include them. She didn't have a federal right to sue, nor did she properly attach a California one. That means she failed to exhaust her administrative remedies, which is a mandatory step before filing a lawsuit. Changing her complaint after the fact doesn't cure this issue unless she asks the court for permission to amend. She didn't do that. So, Fritz's motion makes clear. This is exactly why judgment on the pleadings is appropriate. Even if the court reads all of her allegations in the light most favorable to her, she still fails to state claims that rise to the level of being plausible. Specifically, he argues her sexual harassment, retaliation, failure to supervise, and aiding and abetting claims under California law fail because those statutes don't apply extraterritorially, meaning you can't use California law to sue for conduct outside California. Her CRD right to sue letter, even if valid, would only give her the right to sue in California, not New York. Her attempt to tie federal and California claims together under one case in New York doesn't work. Jurisdiction doesn't stretch that far. She never exhausted administrative remedies against It Ends With Us movie. Her retaliation claims aren't adequately alleged. Her defamation claims are barred under litigation privilege and fair report privilege. And finally, her civil conspiracy claims fail because she never alleged an underlying tort to support them. The kicker? None of these issues require the court to look at any new evidence. Everything is contained within her second amended complaint and the documents tied directly to it. Blake's vague argument that she has voluminous evidence doesn't change anything, because it isn't properly part of this motion. So, in short, Fritz dismantles her letter motion piece by piece. He shows that Wayfair is legally entitled to bring this challenge now, that Blake's procedural arguments are flimsy, and that her substantive claims still fail even if every factual inference is drawn in her favor. Put simply, there's no reason for Blake Lively to scramble to gather discovery evidence in order to oppose this motion, because the motion doesn't depend on discovery at all. It goes directly to the defects on the face of her own pleadings. That's the point. She argues she might amend her complaint yet again, but she never explains why she hasn't done so already, or why the court should permit another amendment at this stage. She's already had multiple chances: the original complaint, the first amended complaint, and then the second amended complaint. You don't get to amend forever. That's not how litigation works. And no amount of amending will fix the fundamental problem that her FEHA claims don't belong in federal court. She's in the wrong forum. If the court grants the motion in whole or in part, Blake's claims will be narrowed. That streamlines the litigation. Fewer claims mean fewer issues for summary judgment later, fewer evidentiary disputes, and ultimately less work for the court. That is exactly the purpose of a Rule 12c motion. If the judge can resolve issues now at the pleading stage, summary judgment might not even be necessary. Fritz also dismantles Blake's suggestion that the motion will delay the March 2026 trial. He reminds the court that fact discovery is still ongoing. No summary judgment motions have been filed, and trial is still more than 5 months away. Courts routinely grant Rule 12c motions at much later procedural stages, even after summary judgment has already been briefed. So the idea that this is too late simply doesn't hold water. Then comes the hypocrisy argument. Blake is asking for an extension because she claims she can't manage discovery and respond to this motion at the same time. But she and her husband have filed numerous sanctions motions throughout discovery, forcing Wayfair to respond to extra filings while still managing their own discovery obligations. If she could file those motions while discovery was underway, there's no reason she can't oppose this one. Granting her request would also create procedural problems. It would push briefing right up against the summary judgment deadline, preventing the court from narrowing the case before those filings. Fritz points out that the court's scheduling order was already revised on September 9th to extend expert discovery until November 14th. But the November 5th deadline for summary judgment wasn't moved. By rule, summary judgment should come after discovery closes, not during it. Wayfair has already proposed a sensible adjustment. Fact discovery closes October 10th, expert reports exchanged October 24th, rebuttal reports due November 7th, expert depositions completed by December 1st, summary judgment motions filed by December 15th. That schedule gives the judge time to decide this motion, allows discovery to finish, and ensures summary judgment is based on a streamlined set of claims. If most of Blake's claims are dismissed, the remaining litigation will be narrower, cleaner, and more efficient for everyone. On top of that, Blake dropped a brand new damages theory on September 30th, just 10 days before expert reports were due. She suddenly introduced a lost profits calculation, which means Wayfair's experts now need more time to analyze her claim. That alone justifies extending the deadlines. As long as trial remains set for March 9th, nothing about this proposal is unreasonable. The only real obstacle is Blake herself, who refuses to agree. Finally, Fritz calls out her mishandling of requests to admit. These are critical in litigation. They narrow down the facts, so summary judgment and trial focus only on what's actually disputed. The deadline to serve them was August 14th. That deadline passed 6 weeks ago, and Blake now wants to revive it without explaining why she missed it in the first place. Future depositions don't prevent serving requests to admit, because their entire purpose is to lock in basic facts. By blowing the deadline, she undercut her own case and now wants the court to bail her out. In sum, the motion highlights Blake's pattern. She pushes for sanctions, filings, and deadlines when it benefits her, but pleads burden and delay when the other side makes its move. Fritz's filing argues that the case should move forward, that judicial efficiency demands it, and that Blake's shifting tactics, from last-minute damages theories to missed deadlines, don't justify another extension. Blake Lively's legal saga has taken yet another shocking twist, and this one could prove fatal to her case if the judge rules the way many experts expect. What we're witnessing is not just a celebrity caught up in courtroom drama, but a textbook example of what happens when deadlines are ignored, procedures are mishandled, and strategy gets drowned out by obsession. What's happening here is almost surreal. The same Blake Lively who has dragged Wayfair through the mud, accusing them of delay, obstruction, and stonewalling, is now caught red-handed missing her own critical deadlines, begging the court for relief after the fact, and scrambling to justify actions that look, to any trained legal eye, like self-inflicted wounds. And the irony is that this could all come down to paperwork she never filed, letters she never served, and deadlines she either ignored or blew past as if the rules didn't apply to her. Let's start with what's at the heart of this mess: a right to sue letter. For anyone who's not deep into litigation, here's how this works. If you're going to bring certain employment law claims, discrimination, retaliation, harassment, you don't just march into court because you feel wronged. The law requires you to go through administrative channels first, usually through state or federal agencies like California's Civil Rights Department, CRD, or the Equal Employment Opportunity Commission, EEOC. These agencies screen the claims, and when they're done, they give you a right to sue letter, which is basically your ticket to file in court. It's a gatekeeping mechanism. Without that letter, your claims are legally defective from the start. And here's the bombshell. Blake Lively, with her team of high-powered attorneys, apparently filed this massive case without properly attaching or disclosing the correct right to sue notices. That is not a minor clerical error. That is a fatal mistake, the kind that can collapse an entire case before discovery even gets rolling. Wayfair's lawyers, of course, jumped on this. Their strategy is simple but devastating. Point out that when Blake first filed, she didn't have the federal authorization to sue over some of the claims she's now parading in court. And once you file, you don't get infinite do-overs. You can't tell the court, "Oops, I messed up, let me backtrack and pretend I had the paperwork." The claims you file rise and fall based on the right to sue you had at the moment you pulled the trigger. That's the law. And if Blake tried to cure the problem later by getting new letters, she had obligations, like telling Wayfair, telling the judge, and properly amending with notice. She didn't. That silence is not just sloppy. It's damning. But that's not all. Let's talk deadlines. Courts operate on strict timelines. Discovery cutoffs, expert report exchanges, summary judgment windows. These are the guardrails that keep litigation from spiraling into chaos. Blake, of all people, should know this. After all, she's filed motion after motion accusing Wayfair of dragging their feet, refusing to hand over documents, and playing procedural games. She painted herself as the crusader for deadlines, the one demanding accountability. And yet here we are, with evidence that she herself completely missed the August 14th deadline to serve her requests for admission, a basic mandatory step that helps narrow the issues for trial. She didn't file them. She didn't ask for an extension. She just let the deadline lapse. And now, months later, she's crying foul and asking the court to forgive it. The hypocrisy is staggering. Think about it. She accuses Wayfair of stonewalling every time they so much as ask for an extra week. But when she blows past her own court-ordered deadline, suddenly it's supposed to be excusable. Judges hate this. The legal system depends on consistency. If you hold your opponent's feet to the fire for every procedural slip, you better have your own house in order. Blake doesn't. And Wayfair's lawyers are highlighting this pattern mercilessly. They're reminding the judge of every sanction motion Blake and her husband filed, every accusation of delay they lobbed, every time they insisted that rules must be followed. And now? Now the shoe is on the other foot, and she's the one who looks careless and inconsistent. The bigger issue is strategy, or rather, the lack of it. Blake has already amended her complaint multiple times. First the original, then the first amended complaint, then the second amended complaint. That's 3 bites at the apple. At some point, enough is enough. The rules don't allow endless amendments just because you keep realizing you filed in the wrong court, used the wrong claims, or forgot the right paperwork. Federal judges especially are wary of what's called infinite amendment syndrome. You don't get to clog the docket forever while you figure out how to properly plead your own case. That's why Wayfair filed what's called a Rule 12C motion, judgment on the pleadings. That motion allows the court to throw out defective claims early, even before discovery is done, if the pleadings themselves are legally insufficient. And here's the kicker. If the court grants that motion, it doesn't just streamline the case, it could eliminate entire categories of claims without ever reaching summary judgment. It's efficient, it preserves judicial resources, and it saves everyone, except Blake, a ton of time. Now here's where the timing gets brutal. Blake is whining that she needs more time because discovery is ongoing, experts are still being deposed, and the case is complex. But Wayfair is reminding the judge that discovery isn't even set to close until October. Expert reports are due shortly after, and trial isn't until March 2026. That's more than 5 months away. Plenty of time. And courts have granted 12C motions at far later stages than this, sometimes even after summary judgment briefing. So her timing argument doesn't hold water. It's a smokescreen. And Wayfair is essentially saying, "Judge, don't buy it." She's not drowning in discovery. She's drowning in her own bad decisions. And let's talk about those damages theories. Out of nowhere, just 10 days before expert reports were due, Blake introduced a brand new damages theory, lost profits. This is litigation malpractice territory. You don't drop a fresh damages claim at the 11th hour, blindsiding the other side. That forces their experts to scramble, reanalyze, and redo work. It's unfair and it reeks of gamesmanship. Wayfair is right to call foul, and they're asking the court to revise the scheduling order to accommodate this mess. Their proposed timeline is reasonable. finish fact discovery, then exchange expert reports, then handle summary judgment. That sequence makes sense. Blake, on the other hand, wants to bulldoze through the schedule on her terms, despite the chaos she caused. And then we get to the heart of the hypocrisy. She's saying she needs extensions because she can't keep up with discovery, while also responding to motions. But this is the same Blake who, during discovery, flooded Wayfair with sanctions motions, forcing them to juggle extra filings on top of depositions and document productions. She made them do double duty, and now she's crying that she can't handle exactly what she put them through. Judges see through this. They know when a party is trying to weaponize procedure, and when that same party suddenly pleads for mercy when the rules cut against them. But the real time bomb here is jurisdiction. Blake's claims under the Fair Employment and Housing Act, FEHA, are not supposed to be in federal court. Period. This is black-letter law. She's in the wrong court. Amending her complaint doesn't fix that. Filing new papers doesn't fix that. The case should never have been in federal court to begin with. And Wayfair is hammering this point. If the judge agrees, those claims are gone. And without them, her case shrinks dramatically. What's left may not even be worth the spectacle. Here's what makes this so jaw-dropping. Blake has world-class attorneys. These are not rookies. They know employment law. They know procedure. They know the importance of right to sue letters. So how did this happen? Some observers believe it's a client control issue, that Blake is calling the shots, demanding aggressive filings, and refusing to listen when her lawyers advise restraint. Others think the lawyers themselves are out over their skis, cutting corners to keep up with her demands. Either way, it's malpractice-adjacent behavior. An experienced employment litigator knows you don't file federal claims without the right letter attached. Period. And yet that's exactly what they did. And here's another devastating wrinkle. Her California right to sue letter explicitly told her that if she wanted to pursue federal claims, she needed to go to the EOC within 30 days. She didn't. Worse, even if she had, she was time-barred. The law gives her 300 days from the last alleged incident of harassment to file with the EEOC. She claims the last incident was May 2023. That means the clock ran out by March 2024. She filed too late. She knew it. Her lawyers knew it. And yet they filed anyway. That means, legally, these claims were dead on arrival from day one. She was suing on a clock that had already expired. It doesn't matter how compelling the story is. Time bars are absolute. Courts don't bend them for celebrities. So what is Wayfair really saying to the judge? They're saying, Judge, don't be distracted by her drama. Don't let her paint us as the villains when she's the one missing deadlines, hiding letters, amending endlessly, and changing theories at the last second. Every single mess we're dealing with right now is her fault, the result of her own choices. She filed in the wrong court. She ignored the EOC,